Good afternoon. Thanks for joining us. We're going to go ahead and get started in just a few moments.
All right, good afternoon, everyone. Hope everyone is staying healthy and safe, having a good fall. Welcome to our continued webinar series. We're going to be discussing estate planning today and really a bit more about advanced estate planning techniques. Want to first say hello to our guests and thank them for joining us. First, Jarrett DiMarzio. Jarrett, as many people know, is a certified financial planner, as well as a certified professional wealth advisor. Has been with Cornerstone many years, and thanks, Jarrett, for joining everybody today.
Yeah, thanks, Jeff.
And we also have some special guests, some really, I would say, very, very bright individuals to help us through the advanced techniques. We have Stanton Geller, who is a partner at Culp, Elliott & Carpenter. And we have another partner, Bill Mills, of, again, Culp, Elliott and Carpenter. So Stanton and Bill, thank you for joining us today.
Thank you, Jeff.
Yeah, thanks, Jeff. I'm Bill, everyone, and Stan's right there across the table.
Well, again, thanks for your time. We appreciate you giving our clients some great insight. So let's go into the agenda and what we're going to talk about. And we're going to do this in a two-part series, but again, today you'll see part one is going to be just the basics. Again, just a quick basic estate planning 101. We'll talk about why 2020 is so important, given all that's going on in the election, everything else that's out there right now. We're going to talk about the difference between estate taxes as well as estate planning. We're going to dive into the cost benefit of trust planning. We're going to share some issues that could sometimes arise when we deal with and set up family trust. We'll talk about the single 2020 gifting structure. A lot of folks are familiar with irrevocable or probably more revocable trust. We'll talk about that, but we're going to talk about just how irrevocable is my trust. We're going to go start diving into some strategies that we think are pertinent at this time. One being a spousal lifetime access trust, sometimes known as a spousal limited access trust, sometimes known as family trust. So we'll talk, I know Stanton and Bill will shed some light on that. We'll dive into the intentionally defective grantor trust, what we call an IDGIT. And then lastly, we'll finish up with a grantor retained annuity trust. Some folks may have listened in prior webinar that Jared and I held, kind of more on the basics of estate planning. Basic estate planning 101 begins with having someone to jump into action if you're incapacitated or unable to act on your behalf. That would be the use of a power of attorney. People are also familiar with healthcare powers of attorney. In terms of trust, when we start thinking about basic trust, one of the most basic trusts is the revocable trust, where you still own the property or assets that are in there. You have control, but you also have controls, what we call beyond the grave, and you put stipulations, time, percentages, as well as beneficiaries behind it, as well as just the understanding of wills. We always like to remind clients that when someone passes, the last place, beyond dying intestate, the last place we really look to pass assets to heirs and charities is really through the will. So a lot of the documents we put prior, beneficiaries, ownership, trust are really more prevalent in terms of passing of assets. The last place we look at is the will. I know as professionals with Bill, Stanton, and Jared and myself, as we meet with our clients to discuss and review estate plans, we remind clients there's a difference between estate planning, estate tax planning, and there's even estate income tax planning. Today, we're really going to dive deeper and address some of the strategies that are appropriate for the times. So we're going to begin with just a quick estate planning, and when we talk about estate planning, it's really about preparing the plans or the estate plans to accomplish quite a few things. One, of course, is the transference of your assets to loved ones with the potential reduction of estate taxes at death if estate taxes is an issue. We're also looking at the preparation and the task to serve that and manage the individual's family assets in the event of that incapacitation, if you have a secondary trustee, or at death, when you pass, your trustee, successor trustee jumps in. It also allows for the control of the transfer of assets according to your wishes and desires. I'd like X amount percentage to be to my children each on a yearly basis. We see a lot of times with trusts where at certain ages, a third will go out at 25, a third at 30, a third at 35, et cetera. It ultimately fulfills the bequest of assets to the heirs, and again, allowing for the estate taxes if estate plans, do have to be prepared by attorneys or that are, we recommend that are experienced in estate law, not real estate attorneys that practice. It's really an estate attorney when we get into these more advanced strategies. So Jarrett, I'm going to pass it over to you kind of to discuss a little bit about, past, present, and future of the estate tax laws.
Yeah, thanks, Jeff. And I think Stanton and Bill would agree, not only should the attorney be very versed on estate planning, but also tax law. Both of these gentlemen are professionals in that area, so they would agree. So let's take a look back over the last 10 years. Certainly has been quite a bit of change when you think about estate tax exemptions. So think back to 2010. 2010 through 2012, you actually saw a huge, a great reduction from what you look at today for the estate tax exemption. State taxes in 2010 through 2012 were based on the Tax Relief and Unemployment Insurance Reauthorization and Job Creation Act. It's a mouthful. President Obama signed that into effect. Previous of that, the state tax exemption was around $1 million per person. But that act passed, increased it to $5 million per person, and was set to adjust for inflation. Well, that was supposed to sunset at the end of 2012, but Congress actually passed the American Taxpayer Relief Act in January of 2013, and that made it permanent. So now fast forward to more recent times, President Trump signed the Tax Cuts and Jobs Act in December of 17. Well, that increased the estate tax exemption from 5 million plus inflation to somewhere around 11 million. Currently, it sits right now at 11.58 million per person. Obviously, a huge increase in the estate tax exemption. Many Americans don't have an estate tax problem. They don't have to worry about that. But obviously, some folks do. And it's certainly something that you need to pay close attention to, because currently any amount above that, state tax is taxed at 40%. So, penny saved is a penny earned, right? So we don't want to give it to the government. And I know Stanton and Bill have a pretty good line about that later, about sharing some of that with them. So I'll leave that to them. But if you take a look at this chart here, you can see over the years how the estate tax exemption has increased, but it's set to sunset at the end of 2025. So you might look at 11.58 million today, or if you're married, 23.16 million per married couple, and say, I don't have an estate tax problem. Well, that might change. Obviously, in 2026, the number is sunsetting and reverting back to what's going to be around 6 million per person. Well, if there's any changes in Washington, that could change. It could change sooner. It could change sooner, and it could be lower. So I think this is a very pertinent time to talk about this. Whether you have an estate tax problem today, you may in the future. So here's another example of our history for estate tax exclusions per person. You can see the dramatic increase. So let's kick it over to Stanton, and he can tell us about the cost benefits of trust planning.
Thank you, Jared. Trusts are an important tool in the estate planning toolbox, maybe a fundamental tool. And that's what Bill and I do. We draft trusts for our clients and for their needs. Trusts have quite a few benefits to them. The first is tax savings. And what do we mean by that? We're talking about the estate tax. And so Jarrett went over the exemption. So right now, all assets in excess of the exemption are assessed an estate tax in this country. And so the benefits, the tax saving benefits of a trust is assets held in trust are not in your taxable estate. That's the fundamental point. And therefore, if they are in trust, they're not subject to estate tax. And that's why they are such an important and fundamental tool in estate planning. The second benefit is creditor protection, which is a nuanced area of law, and it's obviously very important how you draft your trust and you respect your trust. But bottom line, assets in a trust are that, trust assets. They're not the assets of the person who creates it, the settlor. They're not assets of the beneficiary. They're trust assets. So what does that mean? Well, if future creditors come knocking on the door of the settlor or the beneficiary, they're not going to be able to take the assets of the trust. It's not their assets anymore. And again, we could spend an entire seminar on creditor protection of trust, but again, a well-drafted and a well-respected trust should hold up to creditors. Along that line, I'll add, it adds an important marital asset tool. So assets that pass on to your children and grandchildren in trust, again, are trust assets. They're not assets of the beneficiary. So if they encounter a divorce situation, again, those assets are not marital property. And so that's another important element of a trust. Finally, we have vehicle to control family entities. The best way I would explain that is when I'm working on an organizational chart for a client, usually at the very top, it's either individuals or trust. That's the top line. And then all the other entities sort of flow through underneath. And when I say any other entities, I mean operating businesses, I mean family LLCs, real estate, investment, you name it. And so that's sort of the top of the pyramid, and it helps organize your assets for one ownership, and then with the benefits of being able to dictate how those assets flow to your children, grandchildren. So needless to say, trusts are a very powerful tool. I'll get into the perceived cost. One is expense. Yes, it is an expense to draft a trust, and there can be ongoing administrative expense. But I think what we'll show you in this presentation is that from even purely a tax saving side of it, it will more than pay for itself, and it should. And that's one of the reasons you may be drafting a trust, for that tax saving. And then besides that, trusts are accomplishing your family goals, and that's obviously a value. And, you know, trust, again, they can last 25, 50, 100 years. It's a long-term document, and it has tremendous value to you and your family. In fact, that may be another benefit. When you're drafting a trust for yourself, you're not only doing your estate planning, you're doing your children's estate planning and your grandchildren's estate planning, because these assets are going to be stay in trust for their benefit for their lifetimes. So that's another benefit. And finally, as far as another perceived issue of complexity, yes, trust can be a dense document. They have to be basically on all of the law that is passed through our judicial system and the complexity of tax laws. But again, good attorneys, it's important to us that you understand how these trusts work, and we try to boil it down to its simplest terms as far as how they work for you and your future generations. You know, it's important for me and for Bill that our clients walk out of our office not in a haze, and that they understand what they sign and the implications and how they're operated. It's not uncommon to field calls, follow-up calls on how it works, and we welcome that and we expect it. And hopefully we can communicate it in a manageable and simplistic manner. Another con is perceived loss of control, and we'll get into this on the next slide. Yes, the trust needs to own the asset, and you want it to own the asset to get the benefits. But there are elements of flexibility that we put into the trust that help alleviate some of the fears of a loss of control. Jared. So here's a few examples that I would say are within the four corners of the document. And one of the most important is what's called a power of appointment. So what does that mean? Well, let's take an example, not to skip ahead, let's take an example of a family trust or a SLAT where one spouse creates a trust for the other spouse and children. And usually that beneficiary spouse is also a trustee as well, frequently. That spousal trust, and let's say the family has 3 children. If you do nothing, the trust will naturally pour into 3 separate trusts for each of the, and equal shares for each of the 3 children, a third, a third, a third. Well, that spousal trustee with a power of appointment could say, wait a second, I want to give one child 50% and the other children 25%. Or I want to give one child 100% and the other 2 0. There's that added flexibility. You can sort of think of it as a guaranteed visit me provision, and guarantee your children and grandchildren will visit you because you have that power to reshuffle the deck. And you can limit that power to just your family, reallocate among your family, or it could be worldwide. It could be virtually anyone too, which is the ultimate in flexibility for the power of appointment. So that's one example. A second one we have listed, withdrawal rights for beneficiaries. Generally trustees make those decisions, those distribution decisions, and maybe that's not going to work for your family. You want a beneficiary to have the right to withdraw income. You can add things like that to your trust. That has implications as far as taxes and creditor protection, but it's still an option for you if you want something like that for your trust. And the last two I'll sort of combine. There is an important role in the trust called the trust protector. I mentioned you the trustee, and this is the trust protector. And the way I describe it is using a baseball analogy. The trustee is like the manager. They're in the dugout making day-to-day decisions. I mean, they're on the field. The trust protector is like the GM in the skybox looking down upon the manager. You may have a situation where a trust protector does absolutely nothing during the term of the trust, but the trust protector can have powers to remove and replace a trustee that may be not doing what he or she or organization should be doing. And that person can have some amendment powers to change some of the elements of the trust, which is extremely important too. So again, these are examples of how the trust is really more of a living, breathing document than people realize. It's dynamic more than static.
Yeah, and Stanton just covered a lot of the different ways that we try to build flexibility within the 4 corners of the trust document. When we meet with clients, we want to make sure that the document we put in front of them encompasses as many different eventualities as we can think of. However, despite our best efforts, sometimes things come up that we didn't build in a back door for. We didn't contemplate on the front end in terms of flexibility. And so what I would want everyone to understand is that also state law takes care of some of that. And even though these trusts are irrevocable, which, as you all know, in essence means it can't be changed, the reality is there are certain ways to change trust documents under state law. So Stanton and I are sitting in North Carolina right now. We're both licensed in North Carolina. Stanton is licensed in Florida. I'm also licensed in South Carolina. I can tell you all 3 of those states have what is called a decanting statute, a trust decanting statute. And that is a statute that says the trustee can take the assets of one trust and distribute some or all of those assets to a second trust that has similar terms and similar beneficiaries. certain restrictions that are set out in the state law of each state that has that statute. And so that's a power under state law that we use on a very regular basis to address changes in family circumstances, changes in the law, whatever comes up that our clients need us to address with these documents. Because as Stanton mentioned before, our clients intend for these instruments to last for 20, 50, 100 years, and we can't guess everything that's going to come up on the front end. So trust decanting under state law gives us an ability to do that. And a second tool also available under each of those 3 states and most state laws is called a trust modification. And essentially, that's what it sounds like. It's a statute that says, hey, you can change the terms of one of these irrevocable trusts. In almost all states, what that requires is that the person that set up the trust, the settlor, so you as the client, and each beneficiary of the trust sign a consent. In some states, you can do that just on your own without the involvement of a court. In other states, you do have to go before a judge to get that modification made. But again, it's another way that trust instruments can be changed. And so again, if we don't come up with everything at the front end, we like to think that we will and that we're smart enough to see the future, but not always. And so even then, state law is going to provide you some other ways to provide some flexibility to these trusts. Jared.
Great, thank you. That's really good information. Jeff, why don't you tell us about the Spousal Lifetime Access Trust?
Yeah, thanks, Jarrett. And Stanton and Bill, thank you for sharing, because I think one of the big questions, and you already answered, again, how irrevocable is that trust when we set those up? We think it cannot, but it's to remind me, it reminds clients the importance of having the proper documentation set up and having whether it be the trustees, the assignment of the removal of trustees, et cetera, as well as the state law. So if you do move, you may want to look at, is the trust laws in the new state you've moved to maybe more favorable or less favorable? Just looking at all those behind the scenes items and really reaching out. And a good reminder of why we need to review our trust, our wills, our estate plans on at least every few years to just make sure what we want to have happen is continuing to happen. So let's jump into the Spousal Lifetime Access Trust. Like I said, some other names, Spousal Limited Access Trust, could be a family trust. But basically, the Spousal Lifetime Trust is a trust that we're setting up in which we're transferring assets that are to provide creditor protection, avoidance of estate taxes, if there are any, but also indirect access through your spouse. So if we look at, how does that happen? Again, we're looking to utilize our estate or our gifting amount, how much we can give during our lifetime or at our death. Again, we're able to today give $23,160,000 as a couple or partners, or we can utilize our individual gift, $11,580,000. One big item we've been watching, and the IRS issued some guidance and some regulations that there will be no clawback of previously gifted amounts. So that's a big item as to why. And when we say $11,580,000 or $23 million, it's up to that amount, right? You can gift $2 million, $3 million, $1 million, whatever the amount is that you're comfortable. So looking at how that fits into your situation. If someone were to give that $11,580,000, basically we're giving into the trust, we're moving that, the appreciation of those assets going forward is now in the trust. It's available for, if it's your spouse, the beneficial interest is available for his or her well-being, health, maintenance, and well-being for their lifetime, and again, would transfer on to your beneficiaries that you have named. Reciprocal trust doctrine, where the husband sets up one and the wife or partner sets up another. We'll talk about that, but we really have to be careful as to why we would not do that. So we recommend avoiding that. One trust should be for the benefit of the spouse, should not be for each other. You may use your children or other beneficiaries. Benefits is for the donor. You're making your gift and you're utilizing that gift in 2020. It's the best way to ensure that we're getting everything that we can at this time. Again, with, as Jarrett mentioned, the sunset of the estate tax laws in the future, regardless to the election, there could be changes sooner, but we know there's a sunset provision of the estate tax laws in 2025. So just utilizing it today. Even if the exemption were to remain at the high level that it's at, again, we're giving it today. If you live another year, another 10 years, let's say, a great example would be if you gave that 11,580,000 and you transferred it to that trust, and it grew at, let's say, a 5% return over that 10 years, the trust appreciation would have been about 7.2 million at that 5% return, and the estate tax savings on that would have been about $2.9 million that you would have saved based upon the current estate tax rate at 40%. Benefits to the family, could be we're utilizing, the assets are transferring for the benefit, will be protected from claims of the creditors of the spouse or your partner. The spouse and descendants will benefit from the certainty of what the current laws are, and the assets will continue to pass free of estate taxes for your heirs, as Stanton mentioned, children, grandchildren, for further generations. So really great tool to look at today based upon where the current laws are. So Jared, I'm going to push it back to you.
Yeah, thanks, Jeff. Jeff, you mentioned issues with reciprocal trust. Bill, can you dive in on this and tell us, what is a reciprocal trust? What does it mean, and why or why not would we want that?
Yeah, no, happy to do it, Jarrett, and thanks, Jeff, for introducing that concept. This is an issue that a lot of our clients hear these ideas and think about the benefits that Jeff just mentioned, which are, you mean to tell me I can give my $11.5 million now to a trust for the benefit of my spouse? My spouse can take distributions and choose to spend that money on us, or we can invest in a vacation home that we can go travel to together? The answer to all those questions are yes, you can do that. And so the logical question that a lot of people on the call or the webinar might be thinking then is, great, why don't we each do this for each other? Unfortunately, there is a body of law called the reciprocal trust doctrine that says that's not going to work. And of course, we usually see this come up with spouses. It doesn't have to be spouses. It's any two people who set up trusts for one another. So if Stanton and I wanted to set up trusts for each other, the IRS has this doctrine to blow it up. And by blow it up, what I mean is, if I were to set up a trust for Stanton, and then at roughly the same time, he sets up one for me, the IRS can look at this under case law and say, no, what really happened is, Bill, you set up a trust for yourself, and Stanton, you set up a trust for yourself. And the reason they are able to say that is if they can argue that we are both in the same relative economic position that we would have been in, that we're basically sitting in the same shoes, and that there was a quid pro quo, or as the name suggests, that the establishment of the trust was reciprocal in nature. In other words, we wouldn't have done it. I wouldn't have set up a trust for Stan unless I had some sort of surety that he was going to do the same for me. And if the IRS can argue that, as I said before, they'll treat that as me setting up a trust for myself and Stanton setting up a trust for himself. At first blush, that doesn't sound like the worst thing in the world, but it does have very bad consequences that really undoes all of the estate planning. And specifically, in almost all states, if you set up a trust for yourself, or to continue the example, if I set up a trust for myself, I'm not allowed to do that and then still benefit from creditor protection. So almost every state has a law that says, Bill, you can't put your own assets in trust and then go out there and drive like a maniac, run somebody over, get sued, lose everything you have, but still have this stuff that's in trust for you protected. You can't do that. There's strong public policy against it. There are some states that have different laws on that, but North Carolina certainly does not allow that. The other crucial negative to the IRS unwinding the trust via the reciprocal trust doctrine is that the estate tax law says if you establish a trust and you retain an interest in that trust. So again, once they've successfully argued that what Stanton and I did was interrelated or reciprocal, they think that I set up a trust for myself. Once they're able to say that, that means that I established a trust in which I retained an interest. And because they can say that, that entire trust, all the property of that trust rather, gets pulled into my taxable estate when I die. So it doesn't matter if it was worth $5 million when I set it up, $2 million when I set it up, whatever it's worth when I die gets pulled into my estate. So I could make a gift now thinking it's $5 million, it grows to $20 million over time when I die. That full $20 million gets pulled into my estate, which is going to blow all the tax savings that I thought I had. And so that's in essence the reciprocal trust doctrine, which is why we always counsel clients. I know it sounds like a great idea to do 2 family trusts, two spousal lifetime access trusts, but it's really not, because you get into the soup with the IRS of having them have the ability to make this argument. So we would never suggest doing 2 trusts, one for another, at approximately the same time. Perhaps if a trust had been established decades ago, one spouse for the other, then there's no issue of a quid pro quo. Well, then maybe the other spouse could consider the establishment of a trust, and we could include different provisions in the trust to make sure that they're not the same economic position. That's a little beyond where we want to get to today, but I did want to present that idea to you so that you don't head down that road of thinking that 2 spouses should do this for each other. And now Stanton, I think, is going to talk a little bit about what gifting might look like in 2020, where we're making sure we don't have any of these issues.
Yeah, Bill, I know Stanton's eager to talk about how we can avoid doing that, but Jeff and I and other advisors here at Cornerstone, we meet with clients regularly, have conversations about estate planning. Maybe you did your estate planning years ago and you maybe haven't looked at it for quite a while. You might think it's a document, it's filed, it's in the eMoney vault, it's in my safe at home, I'm good, I'm covered. But I think, one of the major things that we're talking about today is not only the estate tax exemption, but also looking over your documents again. Is this a type of a trust planning that you have with your spouse? So Stanton, tell us what we need to think about and what we could do to avoid that.
Sure, and Jared, I'll also say, step 1 for us would be to first review any current estate planning documents to that point and to identify that, because you're right, that's crucial to a full analysis for estate plan. So one solution, and I think it's a rather elegant solution to get around this, is that in this example, we have the husband forming a SLAT as we discussed, but then the wife is forming a trust for their children, a children's trust. And as the name designates, this is a trust solely for the children and grandchildren and not for the other spouse. This is a common way for both spouses to use their exemption amount in a contemporaneous manner. They can do it at the same time and give their full exemption right then and there and not have to worry about the reciprocal trust doctrine. It's rather simple on this chart, but there are some important decisions to be made. For instance, it may make sense for the husband in this situation to gift income producing assets to the family trust, which would allow the wife beneficiary in this example to be distributed that income as she needs it, and for the kids as well. Whereas maybe the wife would contribute more appreciating assets that aren't throwing off as much income because the children just don't need it right now, and they would just rather see their assets grow anyway for the benefit of their children. So this is a great way, again, to use your exemption now, not run afoul of the reciprocal trust doctrine. You can do this contemporaneously as well.
Thanks, Stan. So now we're going to get into what we refer to in strategic trust planning as a freeze technique. So as Jeff mentioned in the agenda, there's a couple of strategies that we'll be talking about in just a few minutes. but I want to introduce the concept. So imagine utilizing your exemption today before it changes, assuming it will, which we do. Take a portion of your taxable estate, if possible, or your estate as it is, and freeze it, move it into a trust, and utilize your exemption. So just as it says here on the slide, these techniques are used every day. Bill and Stanton talked about both of these techniques we're getting ready to describe as something that they do very, very often, especially in 2020. So there's a few rates on the slide here that I want to reference. So Code Section 7520 rate applies to GRATs, and the AFR rate applies to IDGITs. So when you look at these rates and you think, okay, what do they really mean? Well, I like to think of them as hurdle rates. So you're basically trying to have a rate of return higher than these numbers, for example, so that your strategy is successful. So let's go into the first one. So the first one is the IDGIT, or intentionally defective grantor trust. So it is an irrevocable trust, obviously established for the benefit of the grantor's spouse or other descendants. It's designed to move assets outside of your estate, okay? So sounds pretty basic. There are some intricacies in setting up an intentionally defective grantor trust, and I was hoping that Bill can walk us through that.
Right. Thanks, Jarrett. Absolutely. This is, as Jarrett suggested, a transaction that we help clients with all the time. It is a complicated transaction, and every client situation is unique with its own issues that have to be considered. But we want to make a presentation to you where you understand, at least in rough terms, what it looks like and what, how powerful it is in terms of what it can accomplish. And so the goal of this transaction is to move the appreciation of a business interest outside of a client's taxable estate. And it's essentially freezing the value of the business, as Jarrett suggested, as of the moment of the transfer. And now you might be saying, well, I don't have a business. Well, it doesn't necessarily have to be an existing business. A lot of our clients who are interested in this transaction will consolidate their investment assets into a new LLC before doing the transfer. Now, many clients do have operating businesses that they utilize in this type of planning, but just know that maybe you've already sold your business, or you're not a private business owner. That doesn't mean this is not a transaction for you. As I said, you can consolidate assets into an LLC and still accomplish many of these same outcomes. So let's talk in detail about what this transaction looks like. The first part of the transaction is a lot like everything else we've already talked about today. A trust must be established. So you as the client would establish a trust for the benefit perhaps of your spouse, perhaps of just your children, and you'd make an initial gift to that trust. The amount of that initial gift depends in part on the value of the business that you wish to ultimately transfer, because we are going to be selling an interest in your business. So the initial gift should be substantial. And by substantial, I mean it should be large enough to provide the trust with equity to engage in a sale transaction, such that if a third party was talking to the trustee and the trustee said, hey, I'd like to buy an asset from you, that third party is going to look at the trustee and say, yeah, you've got enough assets to support this purchase price. The promissory note you're going to give me, I believe you can stand by your obligations. That's what we're looking at this initial gift stage, is what's going to be enough to provide that equity to the trust. And that does get into a little bit of the weeds with the particular client situation and what will be sold. But that's the essence of the gift. So then the trust is established. And the trust, as Jarrett suggested, is what we call an intentionally defective grantor trust. Now, we, as lawyers, we kind of hate that name because there's nothing defective about it. It's just a quirk of the tax law that we end up calling that. Sometimes you'll hear me just call it a grantor trust. But the key feature there is that if I'm the person establishing the trust, it is a trust that is deemed owned by me for income tax purposes. It's just like a single member LLC in that it's a disregarded entity for income tax purposes. It does not exist. And that is a very key component for the planning. It does not exist for income tax purposes because of rules and regulations that the IRS has put out regarding these types of trusts, and because it's properly drafted to have this feature. But it does exist for estate and gift tax purposes. It has a very important separate existence. And so, as I've said, it's taxed to me. It's treated as owned by me. Well, now as the business owner, I negotiate with the trustee and I agree to sell my business interest to the trust. We're going to have it appraised. We're going to have a third-party business appraiser come in and tell us what is the actual value of this business on the date of transfer. The standard for IRS purposes is what would a willing buyer pay a willing seller for the interest that is sold. The appraiser may consider valuation discounts if they're appropriate for lack of marketability, lack of control, lack of voting rights. Again, all depending on how the business interest is structured, which can even further strengthen the transaction. But once we have it appraised, we sell it to the trust in exchange for a promissory note. So I take back a promissory note as the client or as the seller of this business. And that's the freeze that Jarrett mentioned. Because at the moment I take back that promissory note, the value of that note is equal to the value of the business interest. From a pure estate tax planning standpoint, at that moment, I have not accomplished anything, because if my business is worth $5 million and I've taken back a $5 million promissory note, if I die the next day, I still have $5 million in my estate. But what I have done is I've said, I've put this promissory note in my estate, which is paying interest at that hurdle rate Jarrett mentioned before, which I believe we said in October is 0.38% for this transaction. So long as my business is appreciating at more than 0.38% a year, this transaction will be successful, because every dollar of that appreciation that is above 0.38% a year is outside of my taxable estate for estate tax purposes. And so this is a transaction where you really see the success over a 5-year, 10-year, 20-year time horizon. And we've seen it with many of our clients. If my business interest doubles over a 10-year period, again, all I've got in my taxable estate is a $5 million promissory note. Now I've got a $10 million business interest outside of my estate, which means that $5 million delta, the actual estate tax savings on that are $2 million from doing this transaction. So that's really the power of it, is to get that appreciation out of the taxable estate. There is one additional really powerful feature to this, and that is because this trust is deemed owned by me, I'm still responsible for all of the income taxes it earns. As that business flows through K-1 income to the trust, I pay that out of my own assets. So I take assets that are included in my taxable estate that I haven't done planning with, and I give those to the IRS because I got to pay the tax liability anyway on the income taxes. But every year when I pay the income taxes for the trust, I'm letting the trust grow income tax free, just like it's a 401k. So the assets in that trust are sitting over there, they're growing free of income taxes. I'm using assets that would otherwise attract estate taxes at my death to pay those income tax liabilities. It's like I'm making a tax-free gift to the trust every single year when I file my 1040, and that just has an incredibly powerful feature to transfer wealth to your spouse, to your children, free of estate taxes, and we've seen it work time and time again. Now, the last thing that a lot of our clients think when we present this to them is, gosh, Bill, that could be a pretty big income tax liability that I'm paying over time. I don't know how long I can afford to do that. I don't have, at some point I'm going to run out of other assets. Absolutely, that could happen. Now remember, you've got two things here. You've got a promissory note that's owed to you that has to be paid back at some point. And also, because of the flexibility that we always build into our trust that Stanton has already talked about, we can turn off that feature that causes the clients to be liable for the taxes at any time we want to. So when that tax liability becomes too burdensome, when we've been successful transferring the amount of wealth, we're able to toggle a switch, if you will, and say no more on the income taxes. We've done enough. Enough wealth has been transferred. The kids are going to be fine, whatever the consideration is. And so, again, we would just posit to you this is a very powerful tool that has worked very well for many of our clients as a freeze technique. And I think now we're going to talk about another freeze technique that also has worked very well.
Yeah, thanks, Bill. I'm gonna throw one at you here. I don't think we talked about this in our prior conversation, so I apologize in advance. But I think it's important to know who can access the assets in the trust. Let's say, for example, you mentioned creating an LLC that's actually not a business prior to, but putting investment assets into the LLC. Who can access the trust assets prior to the grantor's death?
Yes, a great question. So it depends who the beneficiaries are in the trust. Most of our clients would layer this with the SLAT that we talked about earlier that Jeff spoke about. So this would be a trust usually for the benefit of the spouse of the individual that created it. There is a variation of this where maybe the spouse of the business owner sets up the trust for the benefit of the business owner. And so the business owner himself or herself actually sells to the trust. So that person both has a promissory note coming to them and is a beneficiary capable of receiving distributions. It's a little more of a complex, maybe even slightly more advanced version of the technique, but it's certainly one that's available that a lot of our clients do. And so and in terms of the access of the wealth, it does get to what we've talked about a little bit before, who should serve in the role of trustee, making those distribution decisions. That's a key component to make sure that wealth, those distributions do come out to the individual that is consistent with the client's goals, whether that is a spouse or children. And then, of course, as I said before, there is this promissory note. So when the client engages in the sale, we know that at some point that promissory note has to get paid back. So there's also access from that way.
Perfect. Thank you. So, one thing that I understand is this seems complicated. That's why there are professionals like Bill and Stanton who draft these more or less on a daily basis. The other thing I want everyone to understand is inside your financial plan, we have the ability to use the planning software to illustrate this. So done one this year with another advisor, Andy Smith, where we're illustrating how an IDGIT can help a client move a real estate asset held through an LLC outside of his estate. And it was very successful in the illustration. And I'll admit he wasn't too excited about it until we showed him up on the screen, hey, this is what it looks like today, and here's what it'll look like, let's say, at your age 95. Big difference with some projections. So I think, if this is something that you could be possibly interested in, it's definitely worth looking at and having the conversation. All right, so another freeze technique that we do pretty often is called a GRAT, a Grantor Retained Annuity Trust. Again, it's an irrevocable trust. You make a one-time transfer of property from which you receive an fixed amount annually for a specified number of years, called the annuity period. So at the end of the annuity period, the payments to you stop. Any property remaining in the trust passes to the persons you named as a trust document as the remainder beneficiaries, for example, your children. Or obviously the property can remain in the trust for their benefit. Had the opportunity to work with Stanton with a mutual client on a GRAT that he developed for a client years ago. So Stanton, can you tell us more about the GRAT and how it works?
Sure, and a GRAT, again, is another great tool in the estate planning tool chest. It's another freeze transaction. So basically what it is like, once again, you're trying to transfer the appreciation of an asset into a trust outside of your taxable estate. So that's the heart and soul of what a grad is. And grads, I sort of think of them as very nimble documents. But what I will say is that the most important number on the screen is in the middle, and it's a 75/20 rate. And right now it's 0.4%. So the first question is, an asset or a class of assets you may be thinking of putting into a grad is, do you think the appreciation will exceed 0.4%? Most people will say yes. And if you say yes, this might be a product for you. If you say absolutely, it's even more attractive. Because again, the appreciation above that hurdle rate is going to be scraped off and poured into a trust that's outside of your taxable estate. And we'll get into some of the pros and cons on the next slide. But again, these are very nimble and they can be structured for one asset or a group of assets, and you can set up one, you can set up 20. You can have them all going at the same time. And if one doesn't perform, so be it. But then if you have a few home runs, then it'd be well worth it as far as moving that appreciation into a trust and outside of your estate. So that's basically grantor retained annuity trust. Again, getting that appreciation, that future appreciation out of your taxable estate. And so what I'll do, let me start with the disadvantages because they're few, but they are notable and you should think about them. The first one has to do with GST, generation skipping transfer planning. We haven't talked too much about that, but basically what GST planning is, if you have a GST trust, then once the assets are in the trust, they are not only outside your taxable estate, but they're outside the taxable estate of your children and your grandchildren and so on. And so you can imagine the power of that, where each generation receives assets and they're not getting a slice taken off for estate taxes. It's an incredibly powerful tool. Grads are not suitable for GST planning. They need to be in a non-GST trust, which means that though it will be outside of your taxable estate, it will at some point be includable in your children's taxable estate. Some clients are fine with that and some are not, and that may be a reason why not to do a grad. A second, if a donor dies during the term of the grad, it's sort of game over. It didn't work. There's no harm, no foul other than the cost of setting it up. It's just going to go right back into your taxable estate. It just doesn't work. One way to mitigate that is in the advantages section is that you can have 2-year grads, which there's more certainty that you'll survive 2 years. And what you could do is if you survive the 2 years, then you could roll the same asset into a similar, if not identical grad for another 2 years and so on and so forth. And that's referred to a rolling grad for obvious reasons. You're rolling into the next one. And so grads can be 2, 5, 10, however the case may be, but 2 years adds flexibility, and once you're done, you may want to stop or you may want to just keep moving that asset forward into another grad. The next point is a loss of basis step up. So this presentation has been focused on folks with taxable estates. Every estate plan should be reviewed for income tax planning, period. And what I mean by income tax planning is that when we all pass away and we have assets in our name and our taxable estate, we all get the basis step up in the sky, which means our children get our surviving spouse and our children get a step up in our basis and our asset equal to fair market value. So if they sold that asset theoretically the next day, there's no gain. So, and that's what I call income tax planning. And so you have to ask yourself, does it make sense to keep this low basis asset in my name and not move the appreciation and not move it into a non-GST trust? So you should always think of that. But again, as far as the advantages, again, I think it's nimble. You could put one asset in there, asset class in there. If you had 5 blocks of stock, you could create a graph for each block of stock. It just is as flexible as you want it to be, which is great. And 2, if you're risk adverse on estate planning. If you're thinking this, you don't want to get the IRS involved in your matters. Grads are blessed by the IRS. They even have a statute. They even show you what forms to use as far as how to draft a grad. So again, and one important point is that grads virtually use none of your exemption. So if you're in a situation where you use your exemption, maybe on a prior gift or what have you, and you're thinking, well, what do I do now? GRAT may be perfect for you. Or you want to save your exemption for another transaction, and you just have a good feeling that there's going to be some appreciation on asset, park it in a GRAT. And if it appreciates, you win. And that appreciation goes into a trust. And again, all the advantages of the trust that we talked before, creditor protection, so on and so forth. So I'm a fan. They're easy to form, they're easy to explain, they're low in risk, and if an asset appreciates well, it can be a home run.
Thanks. Thank you, Bill. Stanton, I appreciate that. So you mentioned home run. Let's bring in the closer here. Jeff, take us through a summary and wrap us up.
Well, thanks, Jarrett. Thanks, Stanton. Bill, as you can see, everyone, we went through a lot. Again, we talked about some of the tax law change that we've gone through over the last 10 years or so. We're also discussing more of the current and of the future. Big reminders in terms of both Jarrett, Stanton, and Bill mentioned, the low interest rates that are shown on the 75/20 or the midterm and long-term rates. That's why the strategies, freeze techniques, are more pertinent than ever. So reviewing those opportunities. Again, working with the current estate tax laws in terms of the use of that spousal lifetime access trust. So we spent some time going over, revocable trust, which is where most people are probably familiar with the use of revocable. But we want to spend a little time on the irrevocable side, and the importance of having the documents prepared properly, having the instruments or the wording within it, the verbiage to where you want it to be. We spent some time going over the freeze techniques that we spent a lot of time and really dove deep into those with the intentional defective grantor trust, as well as the GRAT. Again, great strategies to look at to see how is this a strategy that could be something fits into my overall estate plan. And just like we all said, Bill and Stanton mentioned, it does not have to be a business. It's the use of appreciable assets or appreciating assets where the intentionally defective grantor trust or GRAT can really be a big piece, and great ways to remove these appreciation of assets from our estate. So again, we thank you all for tuning in and listening. We want to thank you for your time. I know, again, a lot of information we went over today. That's why we wanted to break this up into a two-part series. So we're going to, part 2 will be more on charitable remainder trust, charitable uni trust, and we'll get many of our clients, as advisors know, are very philanthropic and very charitable. So we will spend a little time on that. So on behalf of Bill, Stanton, Jarrett, and myself, we wish you all good wealth, and let us know if there's anything we could do for you. Thanks, Bill. Thanks, Stanton.
Thanks
Thanks,
Jared.
everyone.
Thanks, Jared.